Okay, we're gonna go through this one now, and again, I'm gonna repeat it again since these this is being recorded and it's gonna be each question's gonna be separate, so we don't keep it too long in case you're rewatching it. Okay. So there are three methods to going through the MBE questions. You can go from top to bottom, starting at the fact pattern. You can go to the call of the question, then back up to the fact pattern, or you can go call of the question, go down the answer choices, and then go back up to the call of the question or the fact pattern. I mean, excuse me. So let's start with from top to bottom. Here it says, and when you're going through from top to bottom, you are looking for the subject matter they're testing you on, and then identifying the issue, then basically ranking so you can come to the C conclusion, which should appear in the answer choice. It may not be the perfect one, but it'll be close enough. So it starts out a man sued a railroad for personal injury. So now we can see, okay, it's clear now that they're testing us on torts. And in torts, you always want to get a clear picture of who is suing who. So the man is suing the railroad for torts, suffered when his car was struck by a train at an unguarded crossing. A major issue is, so they're giving you possibly an issue whether the train sounded its whistle before arriving at the crossing. The railroad was offered the testimony of a resident who has lived. Now you were thinking it's personal injury, but now it's looking like testimony. We're looking more like an evidence question. Testimony of a resident who has lived near the crossing for 15 years. So it's looking like we're in the evidence realm now. So the way it would work would be you start out thinking that this is torts, and then by the time you get down to here, you're thinking, nope, it's looking more like evidence question. Then the railroad has offered testimony of a resident who has lived near the crossing for 15 years. Although she was not present on the occasion in question, she will testify whenever she is home, the train always sounds its whistle before arriving at the crossing. So if you know you're in the evidence realm and they're saying things like this, the train always, you may be thinking that this is habit evidence they're testing you on. At least that is what I would be thinking. Those are indication that this is what they're testing you on, and habit evidence is admissible. Then the call of the question is the resident's testimony admissible? I am thinking yes, because it's habit evidence. So I'm biased towards the yeses. So I would be thinking more towards the yeses. And it's up to you whether you go from A down to D or just go and look at C and D because you're biased towards the yes, because your conclusion is yes, it's admissible evidence because it's habit evidence. But let's look at A. No, due to the resident's lack of personal knowledge regarding the incident in question. That's okay. She can't get in by personal knowledge, but she can get it in by habit evidence. No, because habit evidence is limited to the conduct of persons, not businesses. I don't believe that is true. I don't remember a rule saying that. So I think even if you didn't, or if you thought that that may be, you weren't sure if that's a rule or not, you can leave it. You can leave it and not cross it out right away to see if the yeses are okay. You still have the yeses, which if you know your evidence rules, you will be thinking it's probably a yes. Okay. So here it says, yes, as evidence of routine practice. And if when I racked it, that was my answer, that this is okay, admissible because it's habit evidence. So I, right here, I would just not worry about B at all, because I know for sure that this is what I got as a C when I racked my answer. So I would definitely pick C, and I wouldn't even look at D, and I move on to the next question. But let's just look at D. D is yes, as a summary of her present sense impression. Of course, it's not present sense impression because she wasn't even there. So it's obviously that's not going to be correct. So you can clearly cross it off. And even if you can't cross off B because you don't know if it's a correct answer or not, I would be more biased towards C because you know um, if your inclination is this. Okay. So I think that's part of the problem of why I really encourage you all to really learn your substantive law. Is it's really between these two. If you knew your habit evidence rules, wow, you wouldn't be distracted by this because there's no such rule. Like if you know your rules backwards and forwards, you know that this is going to be the correct answer. So learn those rules and find ways to learn those rules, and I'll try to help you guys too, like we've been doing. Okay. All right, so let's clear this board, and we will go from the call of the question, and then go through the, go back up to the top, and then go from there to see how it works out. Um, so the call of the question is the resident's testimony admissible? And right away you recognize that you're in evidence and you're looking at testimony evidence. Um, okay. So then testimony. And now you go up to the top. A man sued a railroad for personal injury suffered when his car was struck by a train at an unguarded crossing. At this point, I'm looking for testimony evidence. I don't really, these things don't really matter to me now because I'm looking for testimony. So it doesn't, I don't need to keep track of these facts other than it's in my head and I know I've read it. And that's the difference between reading the fact pattern first or reading the call of the question. We kind of skip over the torts part because we know we're looking for evidence. A major issue is whether the train sounded its whistle before arriving at the crossing. The railroad has offered the testimony of, and then now that piques my interest. It's the defendant offering the testimony of a resident who has lived near the crossing for 15 years. Although she was not present on the occasion in question, she would testify. Here's her testimony. Whenever she is home, the train always sounds its whistle before arriving at the crossing. So now I get a sense of her testimony is about the habit of the way the train is run, how they run the train. So here's habit evidence, and again, I'm thinking yes, it's good habit evidence, and it's admissible, and we're right back at its routine practice. So even though in my mind I'm thinking habit evidence, routine practice, like I said, it doesn't match perfectly, but still, you know that that's what you were thinking. And so you should be biased towards this answer. And so, we don't have to go back to thinking about these. Well, I guess I better, because some of you may be skipping down to going through the answer choice, or just skipping to this part of the video rather than watching it the beginning to end. Okay, so let's go ahead and go through. Is the residence, so at this point, I'm thinking the conclusion is it's habit evidence that's permissible, admissible habit evidence. So is the resident's testimony admissible? I'm thinking yes as my conclusion because it's habit evidence. That's basically I racking. And so I'm biased towards C and D because they are the yes answer choices, and my C is a yes answer choice. So I'm biased towards that. Now, if I read A, no, due to the resident's lack of personal knowledge regarding the incident in question, that's okay. She doesn't need personal knowledge. She can testify towards a habit. She doesn't need personal knowledge. No, because habit evidence is limited to the conduct of persons, not businesses. If you knew the rule, that's not a correct rule, but unfortunately, you have to know that that's not a correct statement of the law, and so that's why it's important to understand your substantive law really well and know some of these rules backwards and forwards. But that's the purpose of doing these questions, is to learn from them. Here, then it says, yes, evidence of routine practice. Like I said, that matches up with your conclusion. So that's looking really good. Here, yes, as a summary of her present sense impressions. She wasn't even there. So how can she have a present sense impression? So that's not a good answer choice at all. That's just, if you pick that, you didn't read the fact pattern very closely. So you weren't paying attention to detail. So the answer choice is C. So the last method, I'm going to clear the board, and we're going to go from call of the question to the answer choices, and then we'll go through, then go back up to the fact pattern. So again, the answer choice here, the call of the question, is the resident's testimony admissible? So you see right away, again, you would be thinking at this point, okay, it's the testing on evidence, and it's about testimony evidence. Okay, that may be important. We don't know yet because this is the first sentence we read from this question. Answer choice A, no, due to the resident's lack of knowledge regarding the incident in question. We don't know the fact pattern, so that may be correct. If she doesn't have, or he doesn't have personal knowledge, then they can't testify towards it. No, because habit evidence is limited to the conduct of persons, not businesses. Because I know the rule, I know that's not true, so I would eliminate it. But if you didn't, then you'd have to leave it blank. But you should know that that's not true. There's no such rule, so you could cross it out. But let's pretend that you didn't know. You just leave it alone. The answer choice C, yes, as evidence of routine practice. So this, you should see, these two are dealing with routine evidence, routine and habit evidence. So this is kind of a hint that they're probably testing you on routine or habit evidence. And so it's looking more like it's one of these answer choices. Okay. So then you go to answer choice D, yes, as a summary of her present sense impressions. Again, we don't have the fact pattern, so unfortunately we can't eliminate that either. So we're going to have to just have all of them open and go through the fact pattern from top to bottom. Starting at the top, you say, a man sued a railroad for personal injury suffered when his car was struck by a train at an unguarded crossing. And a major issue is whether the train sounded its whistle before arriving at the crossing. The railroad was offered the testimony of a resident. And now here, this is where we want to be paying attention. This is the testimony in question. And the testimony is of a resident who has lived near the crossing for 15 years. Although she was not present on the occasion in question, she will testify whenever she is at home, the train always. And so this is a confirmation that they are testing you on habit evidence. So you're thinking that, okay, so it's looking more and more like it's going to be one of these habit answer choices. Um, the train always sounds its whistle before arriving at the crossing. To me, you right here is when you highlight that testing you on habit evidence, and it's going to be one of these answer choices. And unfortunately, it comes down to how well do you know the rules, and hopefully, you will have studied it well enough to know or be biased towards the fact that there's nothing wrong with this habit evidence, um, and just trust that you when you Iraq, it's the conclusion is it's admissible habit evidence, and you pick the answer choice C. Okay, so I'm going to clear the board again and stop this recording. Okay, bye.